So everyone can see my screen?
Yes.
So today, in brief, I'm trying to give a bird's view of Specific Relief Act 1963. Now, this Specific Relief Act 1963 is an act of the Parliament of India assented to on 13th December 1963. Now, the Specific Relief Act 1963 provides for remedies for parties whose civil or contractual rights have been violated. Now, the Specific Relief Act of 1963 replaced an earlier Act of 1877. The 1877 Act was originally drafted upon the lines of the draft of the New York Civil Code 1862, and its main provisions embody the doctrines evolved by the English equity courts, which had previous to the Act been applied in India as principles of equity, justice, and good conscience. Now, let's see what were the objectives behind the enactment of the 1963 Act. Now, the Law Commission of India, in its 9th report dated 19 July 1958, suggested various revisions in the Specific Relief Act of 1877, which in a nutshell were as follows. The main object behind the amendment was to deal with compensatory relief. The intention was to provide for equitable remedies for the first time, such as recovery of possession of property, specific performance of contracts, rectification of instruments, rescission of contracts, cancellation of instruments, declaratory decrees, and injunctions. Now, both the language and the substance of the 1877 Act was improved. All the illustrations that were given in 1877 Act were omitted to avoid any misunderstanding of the law. Now, the main object was to discourage people from taking law into their own hands, however good their title was. There was at the same time also a necessity to facilitate delivery of possession so as to ensure that the title given by the court does not remain a mere paper decree. Now, the important provisions of the Specific Relief Act in brief. It's a very exhaustive act, but I have just tried to extract only the important provisions. Firstly, Section 4. Now, Section 4 deals with provides that specific relief can be granted only for the purpose of enforcing individual civil rights and not for mere purpose of enforcing a penal law. Section 5 and 7 deal with recovery of specific immovable and movable property in the manner provided by the Code of Civil Procedure 1908. Now, Section 34, deals with declaratory reliefs, discretion of the court as to declaration of status or right. Any person entitled to any legal character or to any right as any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for a further relief. Now, there is an exception, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so. Now, Section 37 deals with temporary and perpetual injunctions. Temporary injunctions are such which are to continue until a specific time. It can be filed at any time or stage of the proceedings or until further orders of the court, and they may be granted at any stage of a suit and are regulated by the Code of Civil Procedure 1908. A perpetual injunction can be granted by the decree made at the hearing and upon merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act which would be contrary to the rights of the plaintiff. Now, section 41 clause H, injunction when refused. When equally efficacious remedy can certainly be obtained by any other usual mode of proceeding except in case of breach of trust. Now I'm going into types of injunctions. Now, as I already mentioned, sections 36 and 37 deal with temporary and permanent injunctions. Perpetual injunction in detail, what are the kinds of injunctions and how it can be granted, is dealt with under section 38. Mandatory injunctions, section 37. Damages in lieu or in addition to injunction, section 40. Injunction to perform a negative covenant, section 42. Now, firstly, permanent or perpetual injunction. Now, a party can approach the competent civil court of original jurisdiction seeking prohibition of an act which has not yet been committed, but there is an apprehension of an unauthorized act to be committed or performed. Section 38 of the Specific Relief Act deals with circumstances under which a permanent injunction can be granted. Now, of course, permanent injunction is always subject to a full-fledged trial, unlike a temporary injunction, where just a prima facie case has to be made out by the plaintiff. Now coming to temporary injunction. Now section 37 undoubtedly provides for the grant of temporary injunction. The procedural aspect is governed by Order 39, Rules 1 and 2 of the Code of Civil Procedure. An application for temporary injunction is filed during the pendency of the proceedings. There are numerous judgments which states that the application can be filed at any point of time during the pendency of a suit and not necessarily along with at the time of filing of the suit. The parties approaching the court should make out a prima facie case and establish that the balance of convenience lies in their favor. Temporary injunction is filed during the pendency of a suit and it can't be filed independently. Disobedience of an order granted by the court under Order 39, Rules 1 and 2 of CPC would be dealt in accordance with Order 39, Rule 2A of CPC. Now, if there is any violation of temporary injunction granted by the court, the party will have to file an application under Order 39, Rule 2A of CPC complaining of disobedience. Now, there is no procedure as such set out in Order 39, Rule 2A as to how the application has to be dealt with, but there are several judgments wherein the courts have formulated procedure to deal with an application under Order 39, Rule 2A of CPC. And the court has observed that the disobedience has to be proved. So therefore, usually an application under Order 39 Rule 2A is registered as a separate proceeding, wherein the party complaining of disobedience will have to prove it. And that will be treated as a separate proceeding. Now the court shall make a note in now before granting, when we are at the stage of taking a temporary injunction, the court shall make a notice to the opposite party before granting an injunction under Order 39, Rule 1 and 2 of CPC. However, there is an exception to this rule, which says that the court may grant such injunction without giving a notice to the opposite party when it appears to the court that the object of granting the injunction would be defeated by reason of unnecessary delay. Now, if the court grants an injunction without giving notice to the opposite party, which we all commonly know as ex parte injunction, it shall also record reasons for the same in brief, and the following compliances shall be performed by the applicant. Firstly, the complete set of pleadings together with all the documents, including affidavit, copies of the plaint, which the plaintiff relies upon, has to be immediately served upon the opposite parties against whom the order is taken. Now, if the order of injunction, now when an order of injunction may be varied, set aside or discharged or an application by the party who is dissatisfied with the order of injunction. Now, a person against whom or a party against whom an order of injunction is granted, he has two remedies. Firstly, he can file an application under Order 39 Rule 4 seeking modification or vacation of the interim order, or now the law is settled. The party can also directly approach and file an appeal before the High Court, also seeking the vacation of interim order. Now coming to mandatory injunction. Now mandatory injunction is also commonly known as a prohibitory injunction. Section 37 of the Specific Relief Act deals with mandatory injunction. Now the relief can be granted where it is necessary to prevent the breach of an obligation or compel performance of a party. Now such injunction can be granted under the following circumstances. First of all, there must be an obligation on the part of the defendant to perform certain acts, the breach of which must be alleged by the plaintiff. Secondly, such relief must be enforceable before the court of law. Now, once again, this relief is discretionary and the power to grant mandatory injunction has to be exercised in very exceptional and rare circumstances. Now, the common examples of mandatory injunction would be removal of unauthorized constructions or even restoration of a construction which is unlawfully demolished. Now coming to damages in lieu of or in addition to injunction. Section 40 of the Specific Relief Act provides for the circumstances where the court can grant and reject damages as a relief in lieu of or in addition to the relief of injunction. Now, first of all, the plaintiff in a suit for perpetual injunction, or which is commonly known as permanent injunction under Section 38, or mandatory or prohibitory injunction under Section 39, may claim damages either in addition to or in substitution for such injunction, and the court may, if it thinks fit, award such damages. Now, no relief for damages shall be granted under this section unless the plaintiff has claimed such relief in his plaint, provided that where such no damages have been claimed in the plaint, the court shall, at any stage of the proceedings, allow the plaintiff to amend the plaint on such terms as may be just for including such claim. Now, the dismissal of a suit to prevent breach of an obligation existing in favor of the plaintiff shall bar his right to sue for damages for such breach. Now, injunction to perform a negative covenant. Now, Section 42 provides that at some point of time in a given contract, there may be affirmative agreement to do a certain act coupled with a negative covenant, express or implied not to do a certain other act. Now, the fact that court is unable to compel specific performance of the affirmative part does not mean that it cannot grant an injunction in respect of the negative part. It is necessary in this case that the plaintiff has performed its part mentioned in the contract. Now, the Specific Relief Act 1963, once again, there was a necessity to amend the act. Now the amendments, let's have a look at the amendments to the Specific Relief Act 1963. The Specific Relief Amendment Act 2018 was passed by both houses of Parliament and subsequently received presidential assent on 1st August 2018. It has come into effect from 1st October 2018. Now, what was the necessity for amending the 1963 Act? Now, the statement of object and reasons as set out in the Specific Relief Amendment Bill 2017 provided that the Act of 1963 was not in tune with the rapid economic growth happening in our country and the expansion of infrastructure activities that are needed for the overall development of the country. Now, extensive reforms in the related laws were required to facilitate enforcements of contract, ease of doing business, settlement of disputes in a speedy manner. Therefore, it was proposed to do away with the wider discretion of the court to grant specific performance and to make specific performance of contract a general rule rather than an exception subject to certain limited grounds. Now, the amendments in the 1963 Act, the amended Act 2018 has received mixed reactions. There has been a lot of criticism as well as appreciation insofar as the amendments are concerned. Now, I'll be briefly going through the amendments. Now, the important features of the Amendment Act are such. First of all, additional party entitled to seek recovery of possession. Now, Section 6 provides for filing of a suit by persons for recovery of possession of immovable property. Now, first of all, a person put out of possession, that is dispossessed person, and any person claiming through such dispossessed person. The amendment now additionally permits a person through whom the dispossessed got the possession of the immovable property to file a suit for recovery, which was not permissible under the 1963 Act. Now, Section 10. Specific performance shall be enforced replaces in the discretion of the court. As per the previous scheme of the Act, to obtain a decree of specific performance, a party filing the suit had to appeal to the discretionary powers of the court. Now, the amendment modifies Section 10 by substituting the words, the specific performance of any contract may, in the discretion of the court, be enforced with specific performance of a contract shall be enforced by the court. Now, the effect of such amendment is that the party filing a suit for specific performance of contract will be entitled for the relief of specific performance. Similar discretionary powers of the court in granting specific performance have been substituted with the word shall in relation to trusts under Section 11. Now, coming to power of the courts to engage experts, which is dealt with by inserting Section 14A. Now, the amendment introduces a new provision, that is Section 14A, which will empower and enable the court to engage one or more technical experts to assist on any specific issue involved in a suit. The expert may also be called upon for providing evidence, including production of relevant documents related to the issue. Now, coming to Section 15, which is amalgamation of LLPs, one of which is a party to the contract entitled to seek specific performance. Amendment extends similar now in case of a limited liability partnership. When we have a look at Section 15 clause FA, which states that when a limited liability partnership has entered into a contract and subsequently amalgamated with an other limited liability partnership, the new limited liability partnership which arises out of the said amalgamation is entitled to seek specific performance of the contract. Now, coming to Section 20, which is the most important and significant amendment in the 2018 Act. It provides for substituted performance. Now, the amendment introduces the concept of substituted performance under Section 20. As per the concept, a party who is affected by the breach of contract can choose to get the contract performed by a third party or by its own agency at the cost of the contracting party at default. The affected party has to give prior notice of 30 days to other party expressing his intention to seek substituted performance. But it is also clarified that the party enforcing substituted performance forfeits his rights to get specific performance of the contract enforced through court. Consequently, Section 14 of the Act, which enlists contracts which cannot be specifically enforced, has also been amended by substituting Clause A, which earlier read, a contract for the non-performance of which compensation in money is an adequate relief, with Clause A, which now says where a party to the contract has obtained substituted performance of a contract in accordance with the provisions of Section 20. Now coming to Section 20A, restraint on grant of injunctions in infrastructure project. The amendment has inserted a new section, that is Section 20A, which restrains the court from granting an injunction in a suit involving contract relating to infrastructure, where granting the injunction would cause impediment or delay in progress or completion of an infrastructure project. Now, infrastructure projects have been categorized and listed in the schedule of the Act, and the main categories are transport, energy, water, sanitation, communication, social and commercial infrastructure. Now, the infrastructure subsectors have also been listed under the said respective categories. Now, this is a very significant amendment because previously everyone used to go to court and easily get an ex parte order of temporary injunction, which used to delay the infrastructure projects. Now, by virtue of Section 20A, the scope of granting injunction as against a project which is of vast public importance is very, very, I mean, the power itself, there is a complete restraint, and court cannot grant injunction in infrastructure projects. In fact, we have been using this provision in several of our matters of NHA, and we have also obtained orders using this provision wherein the court has refused to grant injunction, temporary injunction, by virtue of Section 20A when it comes to infrastructure. Now, I'll be dealing with a few landmark judgments. Of course, there are hundreds and hundreds of judgments, but I will be just going through a couple of them, which are very significant. Now, when can a party file a suit for injunction, and when should a party file a suit for declaration? Now, the court, the Honorable Supreme Court, in the case of Anatula Sudhakar versus B. Bucci Reddy, which is reported in AR 2008 SC, SC 2033. For the first time has given some clarity as to when a party should approach the court seeking injunction and when would a suit for declaration lie. Now, the court has highlighted three main points in this judgment. When a plaintiff is in lawful or peaceful possession of a property and such possession is disturbed or threatened by the plaintiff, a suit for injunction simpliciter will lie. A person has a right to protect his possession against any person who does not prove a better title by seeking a prohibitory injunction. But a person in wrongful possession is not entitled to an injunction against the rightful owner. Now, secondly, where the title of the plaintiff is not disputed, but he is not in possession, his remedy is to file a suit for possession and seek in addition, if necessary, an injunction. A person out of his possession cannot seek the relief of injunction simpliciter without claiming the relief of possession. Because whenever a person files a suit for permanent injunction or perpetual injunction, he has to first prove that he was in possession of the property as on the date of filing of the suit. Now, the third important aspect of this judgment is where the plaintiff is in possession, but his title to the property is in dispute or is under a cloud, or where the defendant asserts title thereto, and there is also a threat of dispossession from the defendant, the plaintiff will have to sue for declaration of title and consequential relief of injunction. Where the title of the plaintiff is under a cloud or in dispute, and he is not in possession or not able to establish possession, necessarily the plaintiff will have to file a suit for declaration, possession, and injunction. Now, the second judgment. The manner in which a temporary injunction can be granted under Order 39 Rule 1 of Code of Civil Procedure with respect to a suit for declaration and injunction. Now, the Honorable Supreme Court in the case of Dalpat Kumar versus Prahlad Singh, which is reported in 1992, Volume 1, SEC 719, has broadly set out the manner in which a temporary injunction can be granted in a suit for declaration and injunction. Now, the court has said there are certain ingredients which have to be satisfied. Firstly, there must be a seriously disputed question which is triable before the court on the facts, and there is a probability of the plaintiff being entitled to a relief being asked. Then secondly, the court's interference is necessary to protect the party from the species of injury. In other words, irreparable damage or injury would ensue before the legal right would established in trial. Now, thirdly, the comparative hardship or mischief or inconvenience which is likely to occur from withholding the injunction will be greater than would be likely to arise from granting it. Now, these are the three categories which the court will have to examine before granting a temporary injunction in a suit for declaration and perpetual injunction. Now, the third judgment which I'll be referring to is Mankor versus Hartar, which is reported in 2010, Volume 10, SEC 512. Now, the conduct of the plaintiff plays a vital role in adjudication where he is entitled for the equitable relief of specific performance. Now, the specific performance of contract is based on the principles of equity, that he who seeks equity must do equity. And the plaintiff has to plead that he has always been ready and willing to perform his part of the essential terms of the contract, and he has to prove the same. Thus, it does not suffice on the part of the plaintiff that he is ready and willing to perform his part of the contract, but he has to prove the same. Now, the readiness and willingness on the part of the plaintiff can be inferred from the surrounding circumstances and conduct of the plaintiff, not only prior to the filing of the suit, but during the course of trial. The conduct of the plaintiff must be such that he shall not be blamed in any way for the failure of the contract, and the responsibility exclusively lies upon the defendant. Now, the conduct of the plaintiff plays a vital role in adjudicating whether he is entitled for the discretionary relief of specific performance or not. Now, the last judgment is of the Supreme Court, wherein whether an inclusion of plea of specific relief by way of amendment can be made or not when the relief was not sought at the time of filing of the suit. Now, the Honorable Supreme Court in the case of Vibhag Karmachari Griha Nirman versus Ramesh Chandar and others, reported in 2010, Volume 14, SEC 596, has gone into the importance of Article 34 of the Limitation Act. Now, the period of limitation which is prescribed in Article 54 for filing a suit of specific performance is 3 years from the date fixed for performance, or if no such date is fixed, when the plaintiff has noticed that performance is refused. Now, in the instant case, there was no date for performance fixed, but the court held that omission to include the relief of specific performance in the suit which is filed when it had cause of action to sue for specific performance as relinquishment of that part of its claim. Now, the suit filed by the appellant, the court held that the suit filed by the appellant was hit by the provisions of Order 2, Rule 2 of the Code of Civil Procedure. So therefore, by virtue of this judgment, the court made it clear that once you have voluntarily relinquished the prayer of specific performance, now you cannot come before the court after a lapse of several years and seek an amendment to insert the prayer of specific performance. Now, this in brief was